We are recording.
Okay, I will go ahead and call to order this hearing of July 17th, 2025 for Z0051-25 and Z0052-25 Rothay Road subdivision and zone change. My name is Joe Turner. I'm County's hearings officer. I'll start with some brief announcements and a summary of the process that will follow so everyone understands how you can participate in the hearing today. I start by saying I am not a county employee. I'm licensed as an attorney and trained as a planner. I serve under contract to the Board of Commissioners. I say that so you know you're getting a somewhat independent review of the applications before me today. My role as the hearings officer is to conduct public hearings and make decisions about certain land use matters in Clackamas County. In making those decisions, I'm required to apply the county's existing laws. I am not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Board of Commissioners and Planning Commission to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearings officer, I'm to provide an unbiased decision maker, and I believe I am unbiased with regard to the application before me today. I have not had any pre-hearing contact with any of the parties regarding the substance of the application, and I don't have any interest in the subject property or any of the surrounding properties. However, anyone has the right to challenge my impartiality, to argue that I'm biased in one way or another, and you can do that when it's your opportunity to testify. Procedure will follow. I'll start by asking staff to summarize their staff report, copies of which are available on the county's website. Then the applicant will have the opportunity to present their proposal and respond to the staff report. Then anybody else who wants to testify about the application in support, in opposition, or with questions or concerns may do so. Once everyone has had an initial opportunity to testify, I will give staff and the applicant alone the opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do without taking any further public testimony. Generally, I'll issue a written decision within about 2 weeks after the close of the public record. I'll send my decision to the county. The county will send it to parties of record. So anybody who testifies orally or in writing before the close of the record will be sure and receive a copy of my decision when it's issued. If you decide you don't need to testify, but you want to receive a copy of my decision, you can contact staff and they'll put you on the mailing list as well. Anyone with an interest in this application may offer relevant oral or written testimony, but testimony should be relevant to the applicable approval criteria which are set out in the staff report. Also, please don't repeat testimony offered by yourself or earlier witnesses. I take good notes and I can review the hearing recording if I miss anything. Repeating your testimony doesn't make your case any stronger. This isn't a popularity contest. Whether everybody loves it or everybody hates it is not an issue I get to consider. The only issue before me is whether the application does or does not comply with the applicable approval criteria. However, it's also important that everyone make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me. In order to in order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me with enough specificity that everyone can understand what the issue is. And if the applicant wants to object to any conditions of approval on constitutional grounds, they must raise those issues before me as well. If anyone feels they need more time to prepare, you can ask me to hold the record open or to continue the hearing. If I hold the record open, you'll have an opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. But whether or not the hearing is continued or the record is held open for any other purpose, state law requires that I hold the record open for an additional week for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that right if they choose, but if anybody else wants me to hold the record open or continue the hearing for any other reason, you must make that request before the close of the hearing today. Also, state law requires that I issue a final written decision within 120 days after this application was filed. So there's some limit to how long I can continue the hearing or hold the record open. When it's your opportunity to testify, please begin by stating your name and your full mailing address. Please spell your last name so I get it right, especially for those who are listed by initials or other ways of identifying yourself on my screen. But that concludes my introduction. Staff will give us an overview of the technical process of how you can request to participate in the hearing through the Zoom process. Ms. Fields?
This public hearing is being conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on PC and iPad, you have a raise hand button on the Zoom bar, which is either at the top or bottom of your screen, depending on the device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who is speaking. Staff will call on you when it is time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you provide your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, email the written testimony to jfields@clackamas.us. That is my email. Or you can mail it to Clackamas County Planning and Zoning Division at 150 Beaver Creek Road, Oregon City, Oregon, 97045. The staff contact email address and mailing address is also available on the web page where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. That is today, unless the record is requested to be left open. People who testify and provide their mailing address will receive a copy of the hearings officer written decision. If you do not wish to testify, but would like to receive the decision, you must provide your email or standard mailing address. You can provide that by emailing it to the staff contact for the application or by entering it in the Zoom chat function during this hearing. That concludes the procedural piece of information.
Okay, I'm going to go ahead and proceed with your staff report.
As the hearings officer mentioned earlier, we are here today for Z0051-25 and Z0052-25. These are land use files that include requests for a zone change and requests for a major subdivision that is being reviewed as a planned unit development or a PUD. The current zone of the property is R15. That is a low-density residential zone inside the urban growth boundary. The applicant is proposing that zone to be changed to R10. The difference between these two zones is the density that is allowed in those zones. I'll talk about that later. Additionally, the applicant applied for a major subdivision through the PUD process. Although the applicant did not apply for open space review, the criteria for open space review is very similar to the criteria required for a zone change and a major subdivision through the PUD process. And so the staff report also includes open space review for this proposal. Since the staff report was sent out and since the notice of this hearing was sent out, testimony has been received from members of the public. That testimony includes concern about future development to the northeast that requires public road access and the suitability of the proposed roads to provide that necessary access to the northeast. Concerns about traffic congestion with the addition of the townhomes and additional lots. Emergency access with a road that is one way in, one way out. Environmental degradation, both the loss of trees as well as the quality of the neighborhood and the feel of the neighborhood were mentioned. Lack of parking and the overflow parking from the proposed development in the adjacent neighborhood was a concern, and people pointed out the lack of transit options related to the lack of parking that is available. There was a concern about property values and concern about access to utilities and road during construction, because there is an existing home site adjacent to the property that currently has a 12-foot road access with utilities serving it, and that those utilities and road access would be underneath the proposed road as seen in the site plan. Since the staff report was issued, additional evidence has been provided by the applicant. That includes an exhibit labeled Exhibit 14 that addresses traffic safety. It includes an analysis of the solar access and a request for a modification due to topographical and orientation features of the site, as well as the open space track. And the applicant provided an updated site plan that addresses the existing sewer easement that is on the property in the northernmost portion of the property, northeast portion. The subject property is zoned R15. As I mentioned before, the applicant is proposing to rezone it to R10. Both of those urban low-density residential zones are subject to Section 315 of our zoning code. One of the items to bring your attention to is lot coverage. Because the applicant is proposing a planned unit development, the lot coverage for the zoning district is increased to 65%. Additionally, because the development is proposed as a planned unit development and a townhome development, the side and rear setbacks are reduced for lots that have a rear yard on the inside of the plat. For those lots that are on the perimeter of the plat, the rear setback is still 20 feet. So those townhomes in the northeast section and the southwest section of the plat will need to have a 20-foot rear setback to the edge of the plat. Additionally, ZDO 315 talks about land area. and the district land area for density of developments. This ties directly to section 1012 of our zoning code. And as it currently sits, using the planned unit development and townhome development requirements, the R15 zone would allow a base density of 32 units. As discussed, the applicant is requesting a zone change to R10 that would allow up to 43 units when only a portion of the site is rezoned. In the original request, the applicant requested rezoning about 3 acres of the site to R10 and leaving the remaining portion of the property that has steep slopes and is around the water resource as R15. And under the original request, the density of the R10 zone would be met by the proposal of 43 lots. However, through the design modification of the road, the plan for the site was changed, and the request for the R10, R15 zoning was modified as seen in Exhibit 2J. The updated plan does not include enough square footage in the R10 zoning district to get the 23 home sites as recommended.
43.
43.
I thought you said 23. Did you mean 43?
I did mean 43. Thank you. Yes. The reason I bring this up is one of the comprehensive plan goals that have to be met for a zone change is that there is variety in the zones, and that steep slopes and environmental concerned areas need larger lots. In the comp plan, these larger lots include both the R10 and R15 zones. As seen by the current zoning map, the subject site is identified here in yellow. The R10 zone is adjacent to the subject site, and the R15 is the zone to the south, west, southeast, and northeast of the site. Staff do not find a need to only rezone a portion of the property. I believe that there is enough zoning variety and support to rezone the entire portion as R10. In the staff report, the recommendation for the zone change was a denial because there was not sufficient evidence about the transportation system safety. With the addition of evidence provided by the applicant, since the staff report was written, they have addressed the transportation system safety, and the specialist found that the safety for the R10 zone was met. And so staff find that the zone change as requested from R15 to R10 could be met and comply with the applicable comprehensive plan policies and goals. The application before us is for a planned unit development. One of the reasons for that is because the comprehensive plan has mapped a resource protection open space on the property. This property is located right here and has slopes that are over 20%, as well as waterways that are regulated by the state Department of State Lands, as well as Water Environmental Services. Because of this mapped resource protection open space, the comprehensive plan policies and goals require that this be looked at as a PUD, a planned unit development. A planned unit development is a subdivision that places at a minimum of 20% of the land area in a platted open space tract. As proposed in the application materials, the applicant is proposing to designate more than 20% of the lot as open space. Designating the 25 to 28% of the lot as open space as the applicant proposes allows flexible lot sizes. It also allows for the 65% lot coverage that I discussed earlier. However, it requires that the lots in the subdivision have reasonable access to the open space. And so there are a couple of areas that seem logical to provide that access to the open space, but it is not identified on the plan submitted by the applicant. The open space that is preserved in a tract has to be within 1,000 feet of all of the lots. That is met by the proposal that is in front of you today. As I mentioned, because the site has resource protection open space, it is subject to ZDO 1011, as well as open space review through ZDO 1103. These require a site analysis. The site analysis is also required by the comprehensive plan for a zone change, and the applicant provided a survey of the topography with enough detail to identify the location of the steep slopes. The applicant did an analysis of tree removal and tree protection, as well as an analysis of how to protect the waterway with a 50-foot buffer. So the image you have in front of you shows that the proposed open space, the proposed waterway with the buffer, and the area of the property that is more than a 20% slope. Part of the open space review is not clear and objective, and state law requires that we only consider clear and objective criteria when reviewing land use applications for needed housing. Because this application will result in townhome development or housing development, this is being considered here. The open space review criteria that is not necessarily clear and objective is mirrored by both the zone change criteria as well as the PUD criteria. In the planned unit development criteria, there is a requirement that an HOA, a government organization, or a nonprofit organization hold the ownership of the land that is designated as an open space tract. That mirrors the open space requirements. In the planned unit development section of our code, it requires that the open space be limited to resource protection or recreation, which mirrors the open space requirements. And so staff was able to use the information provided in the application to show how the applicant meets the open space criteria or can meet the open space criteria with conditions of approval. As a major subdivision, the applicant has to provide evidence for all of these development standards that are highlighted in green with check marks. That includes 1002, protection of natural features, which is accomplished through the open space tract. Hazards to safety, such as landslide hazards and steep slopes, which is also addressed primarily through the open space tract, although A few of the lots do have 20% slopes on the site, and future building permits may require a steep slope review by staff prior to having the home approved through a building permit. That is outside of the subdivision criteria, but is something to be aware of, that there are future steep slope reviews that will likely be necessary for housing development in those areas that have more than 20% slope. There are no known historic landmarks or historic corridors on this property. The utilities include water, sewer, and storm drainage management. Utility companies provided statements of use saying that it was feasible for the applicant to meet their requirements. So with conditions of approval, 1006 can be met. 1007 is roads and connectivity. As mentioned, roads and connectivity were a concern of the public. And so Kent is here with us today and can talk more about roads and connectivity. 1010 is signs. The applicant did not include signs in this application. So if a sign is needed in the future, an additional land use application will be required. Open space and parks, I discussed. Lot size and density, I discussed. Planned unit development, I discussed. All of these seem to be met. What was not met when the staff report was issued was solar access. The applicant did not provide any evidence or narrative to address 1017 or to request a modification of the solar access. Therefore, staff recommended denial of the major subdivision because 1017 was not met, and with no evidence, staff was unable to determine if conditions of approval could allow the proposal to meet this section of our zoning code. As I mentioned earlier, the applicant has since provided materials to address 1017 of our zoning code. And so with that, they did request a modification to the north-south orientation of the lots due to the open space tract and orientation of the property. With that, I would highlight the exhibits that talk about transportation. They include exhibits provided by the applicant, including 2E and Exhibit 14, as well as comments and recommended conditions of approval provided by the Transportation and Engineering Program. I would also note that the applicant provided a copy of the design modification approval that was granted through the Transportation and Engineering Department, and that is Exhibit 2H. That's not on this list, but it was discussed in the staff report. The transportation issue, because it is one of those items that are a concern to the public, I would like Kent to be the specialist or the expert to provide any comments or testimony regarding the transportation system and what was found during their review of the transportation that's proposed. And so Ken is granting us with his presence at today's hearing. With that, staff recommended denial in the staff report due to the lack of evidence for traffic safety and solar access. However, with the additional evidence, staff can now recommend approval because with conditions of approval, it appears that the criteria can be met. However, the plan that is before us today may need to be modified slightly to meet those conditions of approval, including full frontage improvements along the northwest section of the plat and dedicating public road access to the properties to the northeast. And so there are some things that will need to be modified from what the applicant is providing us with today, but with conditions of approval, staff think that the criteria could be met. As discussed in our introduction, questions, testimony, and additional evidence can be mailed to me either electronically through my email at jfields@clackamas.us or through the snail mail by mailing it to the Planning and Zoning Division at 150 Beaver Creek Road, Oregon City, Oregon. If you provide additional testimony or evidence, please note the file numbers in your testimony. And if you have any questions after today's hearing, my phone number is 503-742-4510. That concludes my staff presentation.
Thank you, Ms. Fields. I have a couple of clarification questions in the staff report, starting with condition 3 of B as in boy.
3B as in boy.
For one thing to note, there's two conditions 3. So I'm talking about the first one, which starts on page 8. I'll fix that in the final decision. But 3B says include dedicated access to the open space for all residents of the subdivision. Is there a standard for that access? Like vehicle maintenance?
No,
Okay. Or maintenance vehicle is what I meant to say.
no. They just need to be able to have access.
Okay. 3E's 3E requires that the county sign the final plat. But that doesn't seem to be an appropriate condition since it's not within the applicant's control and I don't have any authority to direct the director to do anything. It needs to happen. Go ahead.
This condition of approval is more about if the roads can and utilities are not able to be installed or meet the utility company requirements, that a guarantee is provided that the requirements are made. If you don't like that one, you can remove it, but it ensures that there is a guarantee for the.
Okay, so it just allows for either completion of improvements or provide surety and maintenance.
Yes.
Okay, that makes sense. I missed that part. Page 34 about street lights. Not sure what my question was. I didn't see a condition. The 1,602 ends with as condition the criteria can be met. I didn't see a condition regarding street lights.
And one will need to be added, and I can draft one if you would like.
Assuming I hold the record open, I'd ask if staff could provide some language for that condition, since I assume you have standard language. Page 36. There seems to be a conflict in the finding. The first sentence says the development is within the boundaries of water service system. Towards the end, it says the tax assessor's information that indicates it's not in a water district.
So it is adjacent to the water district, and the water district provided a preliminary statement of feasibility indicating that it could extend service to the site. So that's where the contradiction comes from. While it's not currently served, it's currently served by a well because there's one home on it. However, it is the Oak Lodge Water District serves adjacent properties.
Okay, and I assume that condition requires that they annex into the district.
And meets the requirements of Oak Lodge.
Okay.
Yeah.
Thank you. Page 30. Oh, on page 39, towards the bottom, it says the right-of-way may need to be expanded. I assume that's talking about that stub road to the north. I didn't see a condition to that effect.
Looking at the transportation and engineering comments that were provided, it appeared that the right-of-way was of sufficient width to the north. However, with the testimony provided through exhibit, I believe, number 6, talking about the future development to the northeast, staff, myself, because I am not a transportation engineering engineer or
Sure.
staff of the transportation engineering program, I said it may need to be because there is evidence in the record that more than 7 lots will be served by that stub. And so if the presence of additional lots beyond the 4 that are shown on the site plan requires the width to be increased, I wanted that to be possible.
Do we need a condition to that effect?
Again, I think that is a question for transportation and engineering.
Okay, Mr. Kent, you want to address that one?
With county engineering.
I'm sorry, Mr. Kent, I didn't hear your title and your name.
It's Ken Kent, the senior planner with development engineering with roads and access. In terms of that street stub sort of to the northeast, it was reviewed as part of a design modification. Initially, when the design modification was evaluated, it was looked at as potentially a private access that would serve future potential development. However, in reviewing the zoning code, it's determined that it would need to be a public right-of-way. However, in that design modification, we had looked at a maximum street width, or at least the minimum street width of 20 feet, with at least a sidewalk on one side. And the findings that were provided in the engineering staff report address the urban alternate 1 standard for the local roadway cross-section, which kind of covers the minimum standard that of a public road in Clackamas County local road can have a 20-foot street width. And through this design modification, there were a number of factors. Normally, there's sidewalks on both sides, and there's some additional right-of-way width. But in the design modification, the access that was determined adequate to serve potential future off-site development, it was that 20-foot roadway, at least a sidewalk on one side.
So is 20 foot sufficient to serve the 4 lots on this site and however many lots can be developed on the adjacent property?
It is. Essentially, we have some crossover standards. Public, private roads serving a number of lots can have a 20-foot width. And so through the design modification, we looked at the number of homes potentially that could be served. I mean, there's the potential of, appears to be probably 14 dwelling units. There's quite a bit of topography on all those adjacent lots that may have potential development, but that street stub has either 2 or 3 properties that may have future development. One was a remainder from a subdivision that specifically identified its future access would come from Southeast Rothy Road when development provided such access. And so as it's at least currently provided, the recommendation is that right-of-way will be adequate. I believe I gave the number. I think we mentioned 26 feet of right-of-way with the 20-foot wide road and a 5-foot sidewalk on one side, plus public utility easement adjacent to the right-of-way.
Okay. And it's my understanding that reduced right-of-way was, at least in part, to reduce the potential impacts to the critical areas or the sensitive areas to the east. Is that correct?
Yes, I think because to the east of this site, yeah, it's a steep topography. And so part of in consideration of the design modifications that deal with the rest of the site as well for a reduced right-of-way was based on the fact that, wider right-of-ways would have involved extending development more to the east and the slopes and sort of those sensitive areas. Yes.
Okay, that's what I understood. Appreciate that.
Yeah.
Ms. Fields, this may be back to you. Does that right-of-way need to be expanded statement? Can that be deleted from the finding? Okay.
Yes.
That's what I suspected. Just wanted confirmation.
The staff report was finalized prior to receiving the engineering staff report. And so I will be the
Yeah, I
expert
understand that.
comments from transportation and engineering.
Okay. On page 44, it says fire access standards require 2 points of access, but written approval from the fire marshal will be required, assuming because the fire marshal can approve a single access if mitigation is provided, such as sprinklers or some other, it's within their jurisdiction. Okay.
Yes.
Page 45, we may have addressed this, but the finding at the top of the page, about the middle, it says the design modification effectively approved a 20-foot wide street with sidewalk on one side. That's only for the track C road, is that correct? Right.
Yes.
Thank you. Page 54 and 55. It's too far. Starting on page 54 at the bottom, it says priority open space shall be preserved outright with some exceptions. The finding says that the applicant avoids the disturbance of most of the slopes, over 20%. Are those impacts that's beyond the most, the small impacts they are going to have allowed? How are they allowed? Since it says high priority open space shall be preserved outright, does it fall within those exemptions?
The high priority is for if you look at the high priority, it's the wetlands, the bodies of water, and land over 35% slope.
Okay. So that the 20% slope is, yeah, thank you.
The 20% slope is the second priority open space.
Okay, great, thank you. Page 69 was solar, and I think you've addressed that. And then page 70, not 170. I think there's just a word missing, and I'm going to confirm. Oh, we got to get that in. Bottom of page 70, about the middle, it says, however, the applicant requests an exception to the dimensional requirements for solar access. I assume that should say if, and actually that may go away because you've addressed it. I'll just have to change that. If I approve this application, I'll have to change that finding. So never mind that question. That's the extent of my questions. Thank you. It's the applicant's opportunity to testify. Mr. Dane, I assume you're the applicant? You are the applicant, it's listed.
I am the applicant. Good morning, Mr. Turner, Ms. Fields. I have here today to help answer some questions that you might have, along with some of the technical issues. I have Crystal Array, who's the civil engineer. He's the one with the headphones on. I have Mike Ard to deal with the traffic, transportation, safety issues, which obviously were an issue for the neighbors. I have Bruce Howard, who is the builder from David Weekley Homes, who would answer questions as needed there. First off, I want to thank staff for taking this project over. Ben Blessing was the planner until he decided to resign, and this rather large file was dumped on Joy's desk with very little warning and or notice. She's had a lot of pressure to get this done. So I very much appreciate her time and effort to make this happen.
Mr. Dane, that brought up another issue I forgot to ask. Ms. Fields, where are we with the 120-day clock?
The 120-day clock is ending soon. The record indicated that the applicant did request 2 time extensions, but the 180-day or 120-day clock ends on the 26th of July.
Okay. Thanks. Go ahead, Mr. Dane. Sorry about the interruption.
No, that's fine. Yeah, a couple of the extensions were necessary. I know that Ben had a lot on his plate, so I was trying to give him as much time as possible to work through things. Anyway, Ms. Fields, I'm going to need your assistance on two things. You brought up a site plan, and then you brought up a list of concerns on the two exhibits. I may need to reference those two items as we move forward. If you can potentially put those up when we need them, would that work? Okay. So again, my name is Mark Dane. I'm the owner developer of the property, and what we're proposing is the 43 lot subdivision with the zone change. I've been working with Ben for a long time to try and make sure we had all the ducks in the road. You can see with the 70-page decision without the exhibits, there's quite a lot to get through. But rather than regurgitate Ms. Fields' discussion of the property, I just wanted to be much more specific and tied into the specific sections. As you see, with all the various criteria, there are 5 different options. One, which is that the criteria are met. Secondly, that it's informational only. Thirdly, it's not applicable. Fourth, it can be met with conditions. And then 5, the criteria are not met. So jumping to number 5, where the criteria were not met, as you saw, that was on page 22 and page 69. And those criteria were to do with additional material that was required. And I believe that the traffic issue and the solar issue, those items have now been met, the criteria have been met. So I believe at this point, all criteria for all findings across the board for the zone change in the subdivision have been completely met. What I did want to do was to address a couple of issues that were raised by the neighbors, some of the concerns. Joy, would you be able to bring up those concerns, please?
Are you asking for my summary on
The summary of the summary.
Your PowerPoint, I assume.
Yeah, the PowerPoint summary of concerns. One of the two things there. I think it's very important to make sure the neighbors are heard during these meetings. So the first item, as you can see, is the future development to the northeast requiring a public road access. I've been in communication with the property owner. He has been looking to find a buyer for this property for a while. I've been in conversations too. He did have an opportunity to develop the property when he was developing the rest of his property as a subdivision, but chose not to, essentially because it is extremely steep, 30 to 50 to 70% slopes. My goal in providing the narrowest possible street to the neighbor was to allow him to develop his property with a minimal impact for a street. Normally, a street is 32-foot wide, planted strips and sidewalks in a 48-foot right-of-way. If you were to try to build a wider street than this on his property, given the cross slope, which is 20 to 30% in that location, it would become increasingly expensive and difficult to build the road through there, if not impossible. My goal here was to provide the most accessible, most affordable, and best road for the neighbor. So we have a 20-foot road with a sidewalk on one side, which will be a buildable road on his property. I was trying to provide him with a beneficial response, which was a 20-foot road and a sidewalk on one side, which with a cross grade as it is, would be buildable without huge retaining walls. I'm not quite sure whether or not he understood I was actually trying to do this for his benefit, as opposed to wanting a wider road, which would require substantially more grading and retaining walls and impact to the property. However, as said, the 20-foot public street with the sidewalk on one side does meet the criteria and has met the standards according to the county engineer. The second issue ties into traffic congestion. Obviously, more development does lead to more traffic, which is why we've been working with Ken and have gone the extra mile in reviewing not one, but I think he ended up with like 6 different intersections in the end. We did a much bigger review of the intersections. We also did a crash analysis, and I have Mike Ard who can speak to that to sort of tell you the results of that. But essentially, we met all the criteria there. In terms of the emergency access, we have provided a full circulation of emergency access. Initially, it was going to be a series of stairs, but we provided a circular route allowing 2 points of entry once you get past the first entrance. And that first portion of the street that does come into the property is not narrow. It's 32 feet wide with sidewalks on both sides. The street only becomes narrow when we're on the internal loop. The goal here was to provide a standard 32-foot stub street, if you were, to the property to the west, given the potential for that property to be developed. This ties into one question I have for one of the conditions, which is not clear. I was trying to reach Joy about this, but I know her time has been limited. This is on page 8, which ties into condition 2H, please. 2H, condition 8 of 10, where it says provide sidewalks and street trees on both sides of the public loop road and the western boundary. The western boundary is it's a full street initially, and then it becomes a 2/3 street. There is not room on the west side to provide street trees, period. And then the street wows over, so it's a 2/3 street. Under this condition, we would be required to provide a sidewalk over the street, over the 2/3 of a street. I was wondering if you could bring up the site plan, Joy, for that, please. What I'm looking for is a clarification from Ken that he is requesting a sidewalk where there's room behind the curb.
Mark, that was a condition that I had based on the approval of the design modification that indicated in the proposal 3 that full street improvements
Right.
along tax lot 2200 would be required. And
Yes.
full street improvements, my understanding, includes sidewalks on both sides of the street.
Absolutely, and I understand that. But the actual street had wowed over, so we were basically building 2/3 of the street. As is normal when you go to an adjacent property, you're required to provide fire access and circulation. You're not normally required to provide a full 32-foot street and curbs and gutters and sidewalks on both sides. It's anticipated that when the property to the west develops, they build that portion of the street and their curbs and their gutters and their sidewalks. And that was the design that we had approved with modification. I think this may simply be a clerical clarification error, and I think it was tied to providing the sidewalk on the west side of the street where we had a full street improvement. If you could provide us with that second plan, please. If you could provide us with the plan.
First, I wanted to highlight the condition of approval for full street improvements along tax lot 2200.
Yep.
And then the plan set that you provided yesterday.
No, this actually, the only thing that was changed on that was the lot lines along the north line when we moved everything 5 feet for the north road to get it out of the easement. The road did not change. You can see what we've done there is we provided a full 32-foot wide street and then wowed it over for the neighboring property owner. If we build the street as shown and then run the sidewalk, you can see it squeezes the road down to less than 20 feet. I think the intent of the condition was to request that we put in a sidewalk at the southern portion. If you could pull that down a bit. Right there, so that we would match the sidewalk that's already there off-site. I think that that's what the intent was, but the way that it's written, it could be interpreted to say build the sidewalk over the street. And I just wanted to be clear that I don't think that was the intent. I just want to make sure, because once a condition is written, so that was it. It was a matter of clarification for Ken.
The condition of approval that I wrote included a sidewalk along this property boundary to have a full street improvements on this part of the road. And it's not going over the road. It would need the whole development to shift to allow for room to provide the full street improvements that is required by our code.
So
If
it
Ken-
was your intent that I move the project over.
That was my intent. Now,
Okay.
Ken is the transportation expert, so I will let Ken address your question as well.
Okay, I can address that. And I think part of, as Joy mentioned, those engineering comments came in after the staff report, and some of that has to do with that transition of staffing and timing with everyone's schedules. But the intention of the condition was that the sidewalk and the full street improvement would be along, was it a tax lot 2200, if I'm not mistaken?
Yeah.
And then once your roadway shifts and becomes what we call a 3/4 or 2/3 street, then you're essentially constructing, the full improvements on the easterly side, and the westerly side would be completed at some point in the future, if and when that other tax lot, get that right?
Looks like 200.
Okay, it might have been 200 if that develops. I mean, right now it's a larger property with a house in the middle, but
Yeah.
under zoning and, theoretically it can be redeveloped. It may or may not, but this one
It's a
envisions.
1.5 acre parcel.
Right, so it envisions at some point in the future, it obviously has the potential under current zoning to develop. And then at that time, that property would dedicate some additional right of way and construct the remainder of this street section. So yeah, the sidewalk on both sides is limited to that initial street stub and up to the boundary of the first property.
Does that make sense, Ms. Fields?
Thank you for that clarity, Ken. Yeah, that makes sense.
So
Okay.
should condition 2H be deleted or modified?
It could read that that we have to provide the full street adjacent to the first lot. That's because it was
2200.
developed. I'm not sure there's room to put in street trees as well. Because our goal was to match the existing curb and existing sidewalk just to the south of the property. And there's about 7 feet from the curb to the property line. So we can definitely put in the sidewalk, and normally that's not required. We put in the sidewalk. I'm not sure we could put in the street trees in the like 18-inch to 24-inch gap behind the sidewalk, given the transition with grading and something like that. If we have to, we have to, but I'm not sure that would make a great deal of sense and might require removal of some of the neighbor's vegetation, which I really don't want to do. I don't need to, because the hedge they got along there. But I understand the sidewalk. I think Ken and I were looking at the infrastructure issue rather than the street tree issue. So providing sidewalks, definitely sidewalks and street trees on everything, absolutely, except the western boundary where we're putting in the sidewalk adjacent to that first parcel before wowing over. And the reason was it was very unlikely that that lower parcel would be redeveloped because it has a house on it, and that made sense to me. Outside of that, we agreed to all conditions as written. I believe we provided the findings. Can we go back to the other neighborhood concern stuff? I just want to make sure I can address as much of that as possible. Joy, would you be able to put that back up, please? Thank you. In terms of the environmental degradation, that was primarily issued to the letter where they're talking about removal of the trees on site. There are no trees being removed in the open space, but it was an issue that was raised upon the general removal of the trees on the site. Most of the site was used as a farmstead with various orchards. There are more trees at the northeast corner, but it's still outside the sloped area. In terms of parking, one of the things that we did attempt to do was to make sure there was the greatest amount of parking possible. When you have a 20-foot wide townhome lot and you have a 12-foot driveway, it does not provide much in the way of options for parking, especially when you add a sort of a 3-foot wing. It gives you maybe about 5 foot on each lot. So when you have front entry townhomes with all the parking spaces, Joe, would you be able to bring up the site plan again that shows the driveway locations, please? Thank you, and thank you very much for your help on this. I find it easier just to normally work with staff's materials. If you can see, there you go, that's fine. If you can see the driveways located along the north and then the east, essentially the outside of the loop road, you can see with the location of the driveways, it does not become possible to park anything there. But rather than have everything front loaded to provide parking, what we did was we created an alley so there would be on-street parking around the entire middle of the island where there would be no driveway cuts. So by removing the driveway cuts and having rear loaded, we were able to ensure there was on-street parking along the entire island. We also, where there weren't any driveways at the entry, where we have the 32-foot, parking is permitted on both sides of the street there. So essentially where we don't have driveways, we have parking. What we're trying to do there was maximize the parking, but minimize the amount of impervious surface there. We've done everything we can to maximize the parking on site and on the street without creating a conflict between the driveways and the neighborhood parking. I believe that was pretty much it. I'd like to make sure I can hear the testimony from the neighbors so I can address those as necessary. Mr. Turner, did you want to hear from the traffic engineer or from the civil engineer at this point, or would you prefer to wait till we get testimony and do it then?
Let's go ahead and hear the testimony and go from
Okay,
there.
thank you.
Thank you, Mr. Dane. Ms. Fields?
One note about street trees, it is a requirement of 1007.06, and in the narrative, it sounded like the street trees were behind the sidewalk,
Yes,
but that you're considering these as street trees. As
Yeah.
such, maybe we need to modify that condition to remove the street trees from that condition, but have a condition that the street trees are maintained by the property owners
Yeah.
in perpetuity, because it is a requirement of our zoning code.
yeah, it's not uncommon, certainly with narrow streets. It's going to be in the PUE anyway. It's going to be in the front yard, and that can be part of the homeowners association to ensure that that is enforced. So that can be part of the CCNRs and the homeowners association. That's not a problem.
Okay, if we hold the record open, I'd appreciate a condition language to that effect.
Thank you.
Thank you, Mr. Dane. So now's the opportunity for public testimony. So who'd like to go first? Please click on the raise your hand button and we'll go ahead and call testimony from those names. Jeff Vanderassen. Staff will unmute you. And you'll need to unmute yourself as well, sir.
Okay, can you hear me?
Now we can, yes, sir.
Thank you. My name is Jeff Vanderdawson. Last name spelled V as in
Gosh,
Victor.
I missed that. Thank you.
No problem. It's spelled V as in Victor, Anderdassson. My address is 915 Southwest Rimrock Way, Suite 201, Box 230 in Redmond, Oregon, 97756. My company is Vando Development LLC. I represent the property to the north, who has those properties under the name of Majestic Investments LLC. I further represent Mocker Development, both of which these gentlemen are on the call too. Mocker is a partner in the development. I provide the land use planning and civil engineering services on this project. I've practiced as a planner and professional engineer in the Portland metro area for about the last 32 years. So I did submit written testimony, and you've asked me not to bore you with that again. But I would like some additional clarification to some of the comments that Ken had made. I wasn't able to hear it very well, but if I heard it correctly, the street extension to the north, which is one of our main questions, the street extension to the north would have to be built to the urban alternate 1 listed on the county detail C110. And if I heard him correctly too, that would require 26 feet of pavement. And I'd like to go one step further with that. That typical section for urban alternate 1 requires a 48-foot right of way. I want to make sure that, because the materials that I reviewed, I didn't really see right of ways widths listed in any of the comments. So I want to be clear. I reviewed the design option, or excuse me, the design modification request. One of the options for the main street was to build basically a 48-foot right of way. When Joey had the exhibit up recently, and I guess first off, I'm sure I won't forget, but I want to request that we hold the record open so we have time to review all the additional information and I can respond with additional comments. So get that out of the way.
Happy to do that.
Bring it back up. A big question that I've had from the start, and it's worth apologies, Mr. Turner, but I've mentioned it before. But the recording, if you could pan down lower, that shows the street width of the internal street. That's a 33 foot wide right of way. Minimum's 48. I brought that up in my testimony. I haven't heard any comment to that. And again, I really haven't heard comment on the right of way widths, because I think we've established the fact that the road extension to the north will be public. So that addresses one of our first main concerns. I didn't agree that an option should have been allowed for a private street extension for various reasons. I still feel that way.
It is going to be a public street. Code requires it.
Perfect. Okay, then I'll move on from that. The applicant made some comments about a buildable road. We realize the grading that we would have to do on our own parcel. I appreciate the concerns, but we still would recommend that 48-foot right of way be built out to that minimum required section as spelled out in section standard detail C110.
What was that code section again? Or
It's a standard transportation detail. It's
what was the detail number?
C as in cat 110.
Thank you.
And the road type I'm referring to is urban alternate 1.
Yeah. And what was the pavement width with that?
26 feet.
Okay.
And again, with a right of way of 48.
It's my understanding that the county approved I can't remember if it's modification or some other similar term that the county uses to allow the narrower 33-foot right of way and 26-foot paved road that's shown on the plan. Mr. Kent, is that correct?
Yes, that's correct. Just to clarify, as I mentioned, urban alternate on roadway standards drawing C110 spells out, I think it says the 26-foot street, with the right of way, but through the design modification, that allowed a reduced street width to the 20 feet and sidewalk on one side. So kind of
20 feet between just to the
Perfect.
north boundary, but 26 feet throughout the rest of the subdivision, except for the.
Yes. So it's just that street stub where there was a reduced road width from the C110 all urban alternate 1, as well as the sidewalk on one side.
What's
and,
the right of way width for the 20-foot section?
we have 26 feet.
Okay.
And I don't know if we want to expand further, but I know you'd mentioned some questions about the right of way throughout the site, which, and I just would clarify, I think the loop road has a 33-foot wide right of way, and part of our design modification was to provide for the sidewalk to be partially in the public utility easement, which is something it's somewhat common, but the utility easement for public utilities, sign, slope, and sidewalk can allow the sidewalk itself to be outside the right of way, and there's a condition that allows that except for those cases where there's a garage. Zoning code typically allows a 20-foot, requires a 20-foot setback from a property line to a garage, but that main intent is that from the back of sidewalk to the garage, there's at least 20 feet, so any vehicle parked in front of a garage wouldn't extend it to sidewalk. So that's just kind of a general overview of the internal street. So,
Hey, could you bring up
Mr. Van-
the
Go ahead,
design
Mr. Vanderdessen, I was
modification?
just gonna ask.
Oh, sorry,
Go ahead.
I'm sorry. Could you bring up the design mod document? I think we're all referring to number 2, where it says, proposal C12-215, which is what I referred to. Everything's spelled out and there specifically, I think follows that C110 with the exception of the right of way. So I guess where was it covered that a modification or an option to allow a 33-foot right of way, where is that included? Guess that's a question for Ken.
Mm-hmm.
I would have to look at the document a little more detail. Part of that was in the exhibits that were submitted for the design modification included site plans that showed their proposed right-of-way width. We were primarily looking at the street pavement. This lists the street pavement widths and the sidewalk where street trees would be located. So I think it's a combination of this document covering that, but then the actual submitted site plan showed that. And part of our discussion was dealing with the sidewalk in the right of way as a modification, as well as the parking issue between garages.
So your intent was to approve the 33-foot right of way, is that correct?
Right. The
Okay.
amount of right of way necessary to construct the.
Just for clarity, you might want to submit a revised version of that expressly says that in the your memo during the open record period.
Yes, we can do that.
Ken, you mentioned the sidewalk could go into the public utility easement. I did not see a public utility easement identified in the plan provided by the applicant. And I do not see the public utility easement addressed in proposal 2. That may help clarify it. So there's the 33-foot road right of way. What is the public utility easement that is in addition to the road right of way?
It's 8 feet. Some of that is clarified in the development engineering's findings, as well as the conditions of approval that are recommended.
Okay.
It includes the
In the exhibit that you provided, exhibit 14 okay. Thank you.
Anything else, Mr. Vanderdessen?
And then as we go to the north, back to again, so what I'm hearing is a reduced right-of-way width. That's why I was making an issue with the 33. We couldn't really neck down from 33 to or go back up. So if I look at that design option, it says for the private road, we've already established it to be public. So then it would have to be built. Have to be built at least an alternate 2. Now, I made the point in my written testimony. My client had previous approvals. He owns 2 parcels up there. The one that directs it abuts it directly, and then the parcel to the west of that, which both had previously, as the applicant mentioned correctly, they previously were approved. One was a PUD, one was not. Shadow plats, which I submitted for the record, show the 14 additional lots just based on what was approved then. Again, that approval is, 20 years old, if I remember correctly. A lot of things have changed recently on density and middle housing and all of that. So the potential for how many lots we could get in there, acknowledging topographic constraints and other issues, for lack of a better word, it very well could be much higher than 14, depending on just with us. And there's a piece of property north of our parcel that would have to be served from this roadway also. That's why I would strongly like to make the case that I still think that larger roadway needs to lead into this future development.
Okay. Just to make sure I understand, you think that a wider road needs to be provided to the north boundary to accommodate the number of potential lots that could be developed on the 3 parcels to the north that can be.
That's correct.
Okay.
Yes.
And I understand that. I'll ask staff to address that during the open record period or in their response after the public testimony.
Okay. I think that hits most of my highlights. A lot was discussed there. So, and again, both of my clients are going to provide testimony also, and maybe expand or have additional comments related to my issues. I think that's it for me.
Thank you, sir.
Thank you.
Is there anybody else who'd like to say anything about this application? If so, please click on the raise your hand button now. I'm pausing to let everybody find the raise your hand button, but I'm not. There we go. Jerry Jones Mocker. You'll need to unmute yourself. There we go.
Hi, good morning. Thank you. Can you all hear me fine?
Yep.
Great. My name is Jerry Jones. I'm with Mocker Land and Development. Our headquarters is located here at 1051 Northwest Bond Street in Bend, Oregon. Although we're located in Bend, we do various developments throughout the Northwest, including just over a handful of them in Clackamas County. I have a partner, Jim Pence, with Majestic Investments, who has those properties. Mr. Dane knows Jim. They've met multiple times over the last year. And I'm in communication with Jim as well, as we're both watching this together. Jim's not going to testify, but I can attest to some of the comments that are made. I just want those to go on record to make clear. Sounds like we are going to have an open period following this, which will be great to review. Some of the last minute stuff that was submitted yesterday, we haven't been able to see that, get some clarity to that, and also maybe we can bring some more commentary to what our requests are and what the past communications have been with Mr. Dane. Mr. Pence is telling me that he's been clear with Mr. Dane over these times that he's met. He's even met with coffee. That Jim's plan stays the same. There's no intent to sell that property. The idea is to develop it someday, and so we want to make sure that we preserve the right to develop that. And I'm going a little bit off script here because this is kind of seems like we're almost designing in this hearing, Mr. Hearings Officer. Like I would appreciate more of an application that can be reviewed, attested to its merits, and then conditions of approval put on there, versus trying to have an application and say, hey, let's just get this approved, and now have a long list of conditions that now it's kind of putting that work on an already burdened staff. The road connection is our biggest concern. I appreciate Mr. Dane's comments, like trying to keep our costs down, and I appreciate that, but he hasn't done the analysis that we have done, and we would appreciate Rothy Road to go straight into our property at the size of a typical public street access, so then we can take it from there and do what we want to do on our property. Having it meander through this very dense townhome complex that is out of character for the area. We feel we don't want that for our more larger lots that are actually consistent with the character of this area. I think that's warranted, and certainly appreciate the change to go public versus private. But even if it's a private street at some narrowing, we just don't feel that's the intent of true public access, right? It makes it look like we have to go through Mr. Dane's development just to get to ours, and it almost would appear as our development is a part of his, right? We want that standard right-of-way width. Understanding that there could be some deviations to that with this urban, but we would be fine with a 26-foot paved street, just like he has through his development, and a 33-foot right-of-way, just like he has through his development. But a 26 right-of-way with a 20-foot pavement just does not give us adequate access. I can't add any more emphasis to that. With regards to the zone change, I think you'll find, if this record's left open, a lot more neighborhood coalition that's coming up to say this dense of a townhome does not meet the character of all of the remaining larger lots. Granted, we are all is in a housing crunch. I work with the state as well, and we know that we're trying to bring housing, but it just needs to be in a very thoughtful way. And as a developer myself, right, I'm not accustomed to opposing developments at all, right? But I do want to make sure that we're doing this in a very thoughtful, community-minded way. So I appreciate your comments. I also request that the record be left open so we can review what was submitted yesterday and hopefully collaborate together to come up with something that works for everybody.
Thank you, Mr. Jones.
Thank you.
Is there anybody else who'd like to say anything about this application? Please click on the raise your, there we go. Sandy Baker.
Can you hear me?
Yep.
My name is Sandra Baker. I am currently moving into 6310 Southeast Rothy Road, which is right next to this property. My family and I have lived in the Oak Grove neighborhood for 38 years. For the last 10 years, we lived at 6300 Southeast Rothy Road, and we spent 10 years building the plans for our dream home with every bit of money we had invested. We aren't even currently all the way moved in, and we learned about this development. We spent all this time working with the county planning division. We carefully followed their rules, and we trusted their R15 zoning to protect the low density character of our neighborhood. At no point were we informed or even thought it was possible that a 46 unit development could be approved right next door. Had we known, we wouldn't have built this house. And now we're stuck with a house that's worth much less than we paid for it. Not that that matters. This was supposed to be where we lived our life. I'm 70 years old. When we built our new home, we added a suite for my 92-year-old mom so she could live out her life here with us. She's visited and loved the peace and quiet of our backyard. If this development goes forward, all those trees are going to be gone. There are a bunch of 150 to 200-foot trees that are going down, and they're right next to us. All the forest and the birds that she enjoys now, she's going to be looking at large construction equipment, listening to noise, and dealing with dust and dirt from the destruction of our natural space. When we built, we were limited to removing just 3 trees unless they were directly in the way of the structure. We also couldn't exceed over 48% impervious surface on our 15,000 square foot lot. We followed every rule. When this property went up for sale, our neighbor checked with the county, and he was told that due to the water features, which go through our property too, they couldn't put more than 3 or 4 15,000 square foot lots. So we felt comfortable going ahead and finishing our home. And now we're being told 46 units, hundreds of daily trips, mass grading, tree removal, and near total site coverage will be allowed. It doesn't seem consistent, and frankly, it's not fair. It's also not legal. The development violates section 1007.01C2, which says closed-end streets can't exceed 200 feet and must not serve more than 25 homes. This street already has 15 homes. Adding 46 more is a clear violation and a serious safety risk. The street is so narrow that emergency vehicles can't pass if cars are parked on both sides. That's happened. This property also
And so parking would be prohibited on one side of this road for just that reason.
Yeah, that's not great either. That means we don't have parking in front of our house.
Mhm.
Property also contains mature fir and cedar trees that are 150 feet tall. It prevents erosion and supporting neighboring root systems. So all the trees that are on our property are going to be compromised, and we were hoping to keep trees. It's also a critical habitat corridor. It's got deer, coyotes, rabbits, squirrels, eagles, yes, owls, and they use it for food, shelter, and safe passage. And the parking plan, the way that we counted it, they're using garages, and most people will use their garages for storage. So the street parking is pretty limited to about 25 spaces. We built our home in good faith when we followed every rule. This development doesn't do it. It threatens the neighborhood character, public safety, the environment, and it sets a dangerous precedent. I respectfully ask you to deny this proposal.
Thank you, Ms. Baker.
I
Excuse
also
me.
like to comment on Housing Goal 3 in the Clackamas County Comprehensive Plan. Housing Goal 3, you know, it would be nice if some of these housing goals address the people who already live here and have put their life savings into where they're living. Economic, social, and cultural perspectives influence the aspects of the built environment that create welcoming and livable communities. So let's consider the housing choice, the livability, and the displacement when developing community plans. I feel like this will displace us because my mother can't live here if we're doing this.
Thank you, ma'am. As far as changing the existing comprehensive plan goals, that's something you have to address with the Board of Commissioners. It's not, this development is subject to the standards that were in effect when the application was filed.
And we didn't know about those, and we've been in the county over and
I
over.
understand.
We were told 15,000 square feet had to be
I
used.
understand.
Well, that's
Thank
pretty poor. My husband would also like to talk, and he's on the same computer.
Okay.
My name
And
is
your name?
Baker.
I'm
John
sorry, I
Baker.
missed your- All right, go ahead. Can you state your first name again? I missed that part.
John.
Thank you.
Baker. I live in the same place my wife lives.
Mhm.
I have a great concern that on the bordering of the property where they've got 10 townhouses, my property has a ravine that goes down in my backyard. On the neighboring property where Mr. Dane wants to develop, that ravine has been filled in and there's a 8-inch culvert going underneath the path, and that culvert is not in great shape. So when water collects on my property, it's supposed to go through that culvert and empty out on the other side. My question is, that never should have been filled in because it changed the natural slope of the property. If I stand in my backyard where that culvert is, I'm looking up to his property. Instead of looking up to his property, I should be looking straight into the ravine that goes in, that feeds into the creek. And the method, whoever did this, they used asphalt and dirt to provide substance to make sure that culvert didn't get damaged. Well, the culvert's not going to be able to hold. If that culvert doesn't hold, then I've got a pond in my backyard because there'd be no way for that water to escape. I believe that that property needs to go back to the way God created it, back to normal. That dirt needs to be removed.
It was illegal.
I think it was illegal in the first place because the previous owners just did what they did. And I would like to add, I know this is just on the record, I'm really sad. I'm really sad that Mark's taking such a hard chance at making a whole bunch of money at the expense of wiping out a neighborhood that we're all pretty happy back here. And I realize public housing is necessary in places. This doesn't feel like the right place to put public housing when there's so much distance they have to walk to get to transportation. And Mark, I hope you can live with yourself, but I know it's all about money. It's a big money
Thank you,
grab.
Mr. Baker.
And I'm done. Thank you.
Thank you, sir. Dane, D-A-Y-N-E. I don't have a last name. You'll need to unmute yourself. You're still muted on your end, it looks like. And we're still not hearing you. Your hand has been, Dane's hand has been removed, but they're still muted. Is there anybody else who'd like to say anything about this application? Not seeing anybody. Anything? Oh. W7UZ has their hand raised. You'll need to unmute yourself. There you go.
Are you there?
Yep, I can hear you.
Okay, yeah, my name is Mick Watson. I live at 6335 Southeast Rothy Road. And I have a specific question for Mark. My property is the property that is north side property lot or tax lot 200. I presently have a deeded easement to my property, and your proposed access road for your development is presently upon that easement. And my curiosity is how do I access my home, and all my utilities run through that easement? And during that construction, how do I gain access to my property?
The applicant will have to maintain access to your property during construction. That may require, build half the road at once and then build the other half, so there's always a passage, but that's something they'll have to address during the construction process and engineering. Mr. Dane can expand on that if he wants during his response, but that's the general requirement.
Yes, because that
They
is,
can't cut off your access.
Yeah, that was my understanding. And when I went up to the planning commission and talked to somebody up there, but yeah, all my utilities, power, obviously sewer, gas, water,
I understand.
electric, everything is through that easement. So while that is all being dug up, we don't want to lose any utility or access.
I understand. Thank you, Mr. Watson.
Okay, thank you.
JBRB has their hand raised. And you'll need to unmute yourself. And Mr. Watson, if you can click on the raise your hand button again, thank you. There you, JBRB is now unmuted.
Hi, my name is Robin. My last name is Belozer, Belozer. I live at 15718 Southeast Wills Way. I was looking at pages, I think it was 22 through 26, that has to do with the transportation.
And the staff report, I'm assuming?
Yes, and on the staff report, there says that we can see 336 cars daily coming up Rothy Road. They analyzed 6 different crossroads. Our street is right off Rothy. The next cross street is Norma. Norma has speed bumps on it. And McNary, which if you want to go down to Oakfield Road, has so many potholes in it from the developments that we already have. And we also have another development going on the end of McNary. Anyone who wants to go down to Oaken Road, which will take you to Thiessen and will head you basically north, has speed bumps. We have none. We'll have so much traffic going down our street, and currently we have traffic going down our street over the speed limit.
When you say your street, are you talking about Rothy or?
Well, Rothy, that currently, Rothy Road has no speed bumps. Wills Way has no speed bumps, but Norma has speed bumps.
I understand.
And Oakton has speed bumps.
Yeah, I just want to know which ones didn't, and you've clarified that.
Right.
Go ahead.
When I have talked to traffic control, basically they say the developer is the one who is responsible, or the citizens who live on the road are responsible for speed bumps. We have so much traffic because we have none. We also, our road goes downhill, and there are a lot of people who turn the corner on Rothy and Wills Way that never stop. If we also have a very bad intersection when you try to go onto Norma and make a left-hand turn, visibility is really bad because of the angle the road has changed when it was built originally. And our traffic pattern is going to be unbearable. We have so much traffic on our road currently, let alone if you start with 336 more cars, which will have to come up Rothy because that's the only entrance to that road. It's going to be constant traffic patterns. There will not be anywhere for these people to really go. And having that big of congestion at the end of almost a dead end road currently, and then if they want to develop even more, there's got to be different access. You can't have that many people packed into a spot that is residential. I mean, we've lived here for 25 years. When we bought this road, it didn't even go through. It was developed at the other end. And at that point, we've had all of this additional traffic. People around here park on both sides of our street to try to choke down the traffic because it is so uncontrollable. We have go-karts running down it with little kids in here. We have people that are walking their dogs every day. We have pedestrians walking all over. You start adding this many cars to the road, there's going to be more accidents. And traffic trying to get out onto Thiessen Road currently is crazy. Thiessen Road, if people would just even drive around here at any period of time, the traffic is unbearable. And adding that many more cars in a location is going to just stress everything. McNary hasn't been fixed in the last 25 years, and I don't even know how long it's been there, but the potholes are crazy. People don't seemingly be able to, in Clackamas County, to be able to fill our potholes. And we can't even keep our roads decent. And
I
yet
understand.
you're going to be adding this many more cars to it. I just want to explain, trying to live here with a residential, nice neighborhood, and then you're going to pack in all of these people on a dead-end road.
I
It's
understand,
going
Ms.
to be
Belozer, you've
confusing.
raised that issue and I understand, and I'll address it in my decision.
Okay,
So-
thank you very much.
Thank you, ma'am. Ms. Belozer, if you click on the raise your hand button so we know you've had the opportunity to testify. I'm not seeing any more raised hands. Oh, there we go. Ms. Belozer, I think you raised your hand again. Thank you. Louder Clunas, I'm hoping pronounce it. And looks like you're unmuted.
Yes,
There we
that's
go.
correct. That's correct. Hi, this is Lisa Lauder, and I live at 15653 Southeast Wills Way. And I've also lived here 23 years, like Robin. And I just wanted to reiterate Robin's concerns, because those are the
Okay.
same concerns
Ms.
that I
Clunas, or Ms.
have.
Louder, excuse me. You don't need to reiterate her concerns. I've heard
Okay.
them and I will address them, but reiterating them isn't going to make your case any stronger.
Okay, what I would like to see though is maybe another road that accesses out of the new development that doesn't drive traffic onto our street.
Okay.
Thank you.
Thank you, ma'am. Dane is back. You'll need to unmute yourself again, or you're still muted. I may be having a technical issue here. I am going to hold the record open, so you'll have an opportunity to submit additional written testimony during the open record if we're unable to get you unmuted. But what I would suggest is if you log out and log back in, that might make this work. And if you want to try that, I'm going to go to the staff and the applicant's testimony, but if you come back and raise your hand, I'll give you a chance to testify. But at this point, we're unable to hear you. So if you want to try logging out and logging back in, we'll do that. If not, you can submit your testimony in writing during the open record. Ms. Fields, anything further any response from the county?
Nothing further.
Okay. Mr. Dane?
Just very briefly, I've taken some notes from some of the neighbors, and I am available to talk or email. My number, if you want to write it down, is 503-332-7167. Again, 503-332-7167. And my email address is markdaneplanning@gmail.com. Again, that's markdaneplanning@gmail.com. A couple of items. The project is not a closed-end street. It actually has two street stubs. It's not a cul-de-sac, so it's not defined as a closed-end street. We are providing two street stubs. And for Mr. Pence, the adjacent property owner, what we're providing is two travel lanes, two 10-foot travel lanes with no parking. If Mr. Pence wants to widen the street on his property, do a 32-foot street and a 48-foot right-of-way, he is well within his power to do so. So he can provide the on-street parking for his homes on his property, and he can do whatever he wants with his property. What we're providing is a sidewalk and two travel lane, two 10-foot travel lane, which is the standard for every street, every local street, everywhere. With regards to our neighbors to the south with the new home, the rear property, the rear yards will be adjacent to that, and we'll be trying to retain any of those trees right along the edge. But currently there's actually a driveway there. It's not like a cluster of trees. The driveway is right on the property line. But for those trees right on the property line, I don't see us having to do anything there. Related to that culvert, it looks like it was put in maybe 40, 50 years ago by the previous owners. It looked like it went out to another house. It looks like it burned down a couple of decades ago. There's a foundation there. The culvert remains and it drains. We are not going to be touching or filling that culvert. We're not going to be touching the drainage way. We're staying away from the creeks. We're not touching any of that. There's no reason for anything not to continue as it is. But again, I'm happy to discuss this. I did want to confirm about the timeline again. Can we figure out how this is going to work with the timeline, given the 120 days, 180 days? I just want to work on the technicalities on this.
If we're going to hold the record open, which has been requested, I'm required to do, but I'll ask you if you want to, if you're willing to extend the 120-day clock to accommodate that. Generally, what I would do is hold it open for a total of 3 weeks. 1 week for anybody to submit new evidence, 1 week for everybody to respond to whatever was submitted during this first week, and then 1 week for the applicant's final argument. And if I can have 2 weeks to get my decision out after that, let's get my calendar out. We can talk about specific dates.
Sure. You couldn't find a big one?
I missed what you said.
I said you couldn't find a bigger one?
Oh, I can see this from across the room. That's what matters sometimes. Today's the 17th. 120-day clock currently expires the 26th. So we have just over a week. But if I'm going to hold it up for 3 weeks, would be 31st, 7th. Mr. Dane, would you be willing to hold the 120-day clock until August 28th to
August 28th? Wow.
Because that's 3 weeks for open record, 24th for 1 week for new, 31st for everybody to respond, 14th for the 7th for the applicant's final argument. That would give me 2 weeks till the 21st to get my decision out. The 28th would give us a little bit of, wait, I got a vacation in there. Until the 16th, I leave the 17th, so I will have to get it out before then. And I will do so.
Well, if you're leaving on the 17th, then let's extend it to the 18th, I guess. So
I appreciate that.
That makes sense. Okay.
Yeah. Of August.
Yep.
And if you'd submit that in writing during the open record period, I appreciate it.
Yes, of course, yes.
So did you want to add anything else then? Because that's what I'm going to hold the record open for 3 weeks.
Yeah, no, I think I'll have my traffic engineer, my civil engineer will be providing additional comments to respond to some of the neighbors, but we prefer to do that in writing to make sure all the T's are crossed and I's are dotted.
Okay.
But I want to thank everybody for the time. I appreciate my engineer showing up, and I want to thank the neighbors. I know that this is difficult. Regards to the driveway, I can talk specifically to that neighbor about how we're going to do it and how we're going to make it work to minimize the issue. There's always disruption with construction, and I apologize for that. We'll try to keep it to a minimum. And I know regarding what you would say affordable housing, everybody likes the concept of affordable housing, except when it's built close to them. I understand, and I know it's a difficult issue. But that's what the Middle Housing Code was designed for, because nothing else was working. We finally have an opportunity to do something here, and I'm hopeful that we can. It would be nice for the diversity in the area, in the neighborhood, and provide some housing for our kids in the region. So I understand the concern, but we'll do the best we can. Anyway, thank you very much for your time.
Thank you, Mr. Dane. With that, I'm going to close the close the hearing. I'm going to hold the record open, as I said, until for 1 week until July 24th for anybody to submit new testimony and evidence. And second week until July 31st for anybody to respond to whatever was submitted during the first week. No new issues can be raised during that second period. And then for a third week until August 7th for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that or submit their final argument sooner if they choose. But as soon as I hear from the applicant that they want to close the record, I will do so anytime after the 31st of July. Anything anybody wants to submit has to be physically received by the county by 4 p.m. on the relevant date, the 17th, the 24th, the 31st, or the 7th. So you can send it to Ms. Fields. If you mail it, you need to make sure you give it enough time to get there to the county by 4 p.m. on the relevant dates. Then I will issue my decision on this thing no later than the 15th of August. And I will send my decision to the county. The county will send it to parties of record. So anybody who did testify already or has testified during the does testify during the open record in writing will be sure and receive a copy of my decision, or as I noted, you can contact Ms. Fields to be placed on the list. I see a number of raised hands, but I've closed the hearing. The opportunity for public comment, oral public comment at the hearing has ended, so I'm not going to address those. But I will hold the record open as I stated, and that concludes our hearing. Thank you all.
Thank you. Bruce, I'll give you a call in a few minutes. Mike, I'm just going to quick chat with you and Chris. Thank you.